Judge Morris upon presiding. May be seated.
Good morning, guys. This is the matter of Town of Haverhill versus Donahue, Tucker, and Ciandella, PLLC, docket number 215-2023, CV 241. Matter is scheduled for hearing on motions for summary judgment. If counsel can please identify yourselves for the record, beginning with plaintiff's counsel.
Thank you, Derek Klein, Your Honor, for the Town of Haverhill. I also have with me the Chairman of the Select Board, Rod O'Shana, the Vice Chairman, Joe Longacre, and also Ron Grover. Thank you.
Thank you.
Good morning, Your Honor. Tara Lynch for the defendant and counterclaim plaintiff, Donahue, Tucker, and Ciandella.
Good morning.
Morning.
So who goes first?
The town, Your Honor, we made a motion in March 18th to make a principal motion. And so I would respectfully ask that the town go first.
You disagree?
I think that's appropriate, Your Honor, except before attorney time begins. On Friday afternoon, the town uploaded what they call Hearing Exhibit 1. It's an affidavit from Peter Roth, a former attorney at the Department of Revenue Administration. It is not in the summary judgment record. It is a new document. There's no motion for leave to supplement the summary judgment record. Attorney Roth is not identified on the town's Rule 22 disclosures as a witness, and it's also immaterial. So I would ask that before Attorney Klein begins argument and references that exhibit outside the record, that Your Honor conclude it.
Your Honor, the record's still open. The DTC had objected to Peter Roth's letter, which is attached as Exhibit 15 to the town's complaint. They complained that there wasn't an affidavit that the town submitted into the summary judgment record. And now there is an affidavit that's submitted into the summary judgment record. All the affidavit does is say that the letter was true to and accurate to Mr. Roth's belief. It doesn't change the facts. And we respectfully ask that it be admitted.
Who's here for the...
Your Honor, the town moved for summary judgment, as counsel mentioned, on March 18th, attempting to supplement the record some 6 months later, business hours before the hearing on the motion. Is just wholly inappropriate. It gives me no time to prepare. It alters the record. I would argue that we just simply argue the record as it exists. It's already extremely voluminous. It contains a number of immaterial matters. I don't think we need to be introducing more immaterial information.
Your Honor,
Look at this record, so voluminous, frankly. I mean, I have the consolidated in my hand here, my little right hand. I've never seen a consolidated statement of material, undisputed facts. It's over 100 pages. I can't tell you without reviewing the whole record. So I'm just going to take your objection under advisement. Go ahead.
Thank you, Your Honor. Good morning. This case is simple.
It is?
Yes.
It's simple? Okay, it better be, because there's a lot of paper.
Okay, and what's at stake is more than a $14,000 attorney bill sent to the personal home of a former select board member. The integrity of local government and how lawyers can be hired is at stake. It's to protect the taxpayers and ensure that the laws of the state are followed when attorneys are working with local government. While DTC has made a significant attempt to make a genuine issue of material fact, one thing is certain, Your Honor, is that the law is clear on conflicts of interest. And DTC engaged in a conflict of interest and is not eligible for attorney's fees under New Hampshire's common law standard established in re Estate of McCool. First, the conflict between DTC and the town was non-consentable on two separate and independent grounds, Your Honor. The first ground is under New Hampshire's unique legal standard on non-consentable conflicts established in Boyle's case, when a disinterested lawyer would conclude that the client should not agree to the representation under the circumstances, the lawyer involved cannot properly ask for an agreement or provide representation on the basis of the client's consent. Importantly, Your Honor, DTC's pleadings do not even address this standard. They claim that the town cited the wrong law, but they don't cite any law themselves. This is the law. And the second ground DTC's conflict is non-consentable is that at the heart of its conflict is two governmental entities, Haverhill and Woodsville. And the New Hampshire rules of professional conduct refer to decisional law in other states that prohibit consent from public entities regarding waiving the public's conflict. I will refer to this as the public interest standard, Your Honor. Thus, there are two independent grounds for why DTC's conflict with Haverhill was non-consentable, and the root of them both, Your Honor, is to protect and promote the public interest and the integrity of the judicial system. Now, on the first ground, the disinterested lawyer standard, Your Honor, a disinterested lawyer looking at the facts, the voluminous facts that you showed in your hand, would conclude that the town should not agree to representation under the circumstances, and DTC cannot properly ask for such an agreement or provide representation on the basis of the town's consent. Now, the representation at issue here, Your Honor, and the only one that's set forth in DTC's conflict waiver letter was the DRA tax rate matter. The DRA tax rate matter boils down to the DRA's refusal to set the town's tax rates because Woodsville appealed the DRA's decision to disallow Haverhill's warrant articles 27 and 28, which mandated that Haverhill taxpayers fund Woodsville's highway department and fire service operations. DTC's secondary representation, which was not addressed in DTC's conflict waiver letter, was review of the town manager, or the former town manager, Bridget Codling's performance, which created its own conflict problems, Your Honor. Now, DTC Attorney Hawkins, which is at the root of this conflict issue, represented Woodsville in litigation against Haverhill to compel Haverhill to fund Woodsville's highway department. And this is where both Attorney Hawkins and former town manager Codling were rivals. And DTC Hawkins also represented Woodsville's ambulance service in its dispute with the town, as shown in Exhibits 83 and 84, where again Hawkins and Codling were rivals. Hawkins was more of a general counsel to Woodsville, Your Honor. Hawkins' prior representation of Woodsville against Haverhill over highway funding and the DRA tax rate matter, which at its core was about Woodsville's efforts to have Haverhill fund its highway departments, demonstrates the two matters were substantially related and a conflict existed on its face. But, Your Honor, what demonstrates the clear conflict here is the email that was withheld from discovery, which is attached as Exhibit 72, where within 30 days of DTC's billing entry on the town, Attorney Hawkins wrote to Woodsville's district administrator, Kevin Shelton, stating that he hopes Woodsville got a lot of money from Haverhill in the settlement of the highway funding court dispute, and that Bridget Codling got burned in the process. So this evidence demonstrates that Hawkins was not simply a litigator for Woodsville. He was invested in Woodsville, communicating with the administrator after he purportedly left the case, and not only hoping that Woodsville received a lot of money from Haverhill in the dispute that he apparently left, but that the town manager got burned in the process. So how could any disinterested lawyer, after reviewing these emails in Exhibit 72, conclude that the town should agree to representation with DTC on the tax rate matter or to review Ms. Codling's performance after he wrote such an email? Moreover, Your Honor, I would point the court to Exhibit 27, which is an email between Ms. Codling and attorney Christopher Bolt, where on January 12th, Codling writes, after discovering Hawkins was an attorney for DTC, that it would be unethical for Hawkins to work for the town due to his prior representation of Woodsville against Haverhill. However, DTC did nothing in response to Codling's email. The undisputed facts demonstrate that DTC entered its purported representation of Haverhill in a partisan, cagey way, Your Honor. They avoided the town manager at every turn and operated in secrecy. They refused to perform a conflict check for the town manager and deliberately remained silent on repeated requests for a conflict check. They drafted a conflict waiver knowingly in a way that it would not support the town manager's position on Woodsville. There's an email that says that. Even though the town manager's position on the Woodsville highway funding issue was the same as the state of New Hampshire's position on the Woodsville highway funding issue, and they said it was improper. So in other words, the town manager's position on Woodsville was not personal, but one mandated by the state at the time. So a disinterested lawyer, looking at all these facts, the ones that you held up, Your Honor, would conclude that DTC's conflict was non-consentable. No disinterested lawyer would draft a conflict waiver letter avoiding the town manager's position on a matter related to Woodsville when that conflicted lawyer formerly worked for Woodsville against Haverhill, and when the select board had granted full authority to the town manager over all legal matters related to Woodsville, as shown as in Exhibit 1 to the town's complaint. And, Your Honor, no disinterested lawyer would draft an email to the select board to send to town administration stating there was no conflict, and drafted a public statement for the select board to say to the public that there was no conflict, after acknowledging there was a concurrent conflict by submitting a conflict waiver letter for signature. It should be mentioned, Your Honor, that in the deposition testimony of Selectman Knapp that's attached as Exhibit 71 and referenced in our briefing, that at his deposition he testified to the self-interest of Hawkins in representing Haverhill because he believed there were bad eggs. And because they were adverse to Haverhill funding Woodsville's highway department and fire services operations. So, Your Honor, because of Hawkins' responsibility to Woodsville and his self-interest in the same, DTC was not even permitted to seek consent from Haverhill to represent it on the DRA tax rate matter and review Ms. Codling's performance, a person who we thought should be burned. So a disinterested lawyer would conclude that this conflict was insuperable, Your Honor, and DTC engaged in a conflict of interest. The disinterest of the lawyer's standard set forth in Boyle is met, and the court should find that as a matter of law, DTC engaged in a conflict and the town should not be responsible for any legal fees. And now, on the second standard, Your Honor, the government standard for conflicts of interest and the appearance of impropriety, on the second ground that DTC's conflict is non-consentable is that it's under the public interest standard. Now, the New Hampshire rules of professional conduct observe that decisional law in some states limits the ability of a government client, such as Haverhill or Woodsville, to consent to a conflict of interest. Now, the basis of this prohibition, Your Honor, is not in a concern for the attorney's ability to represent clients adequately and competently with adverse interests, but in the protection of the public trust and the integrity of the judicial system. This renders the prohibition separate from the beliefs or opinions of attorneys and clients concerning the waivability of conflicts arising from a particular attorney's representation. Even the appearance of a conflict is to be avoided for the sake of the public faith in the integrity of the judicial system when the public interest is triggered, like it has been triggered here. The mere appearance of impropriety, Your Honor, it undermines the public's faith that the process is fair. Now, the appearance of impropriety here, Your Honor, is glaring. We have an attorney from DTC who formerly represented Woodsville against Haverhill regarding highway funding, who has a documented disdain for and rivalry with former town manager Bridget Codling, who attempted to represent the town on the DRA tax rate setting matter, which was about DRA's refusal to set the tax rates because of Woodsville's appeal of Haverhill's warrant articles 27 and 28, which specifically related to highway funding, which was the genesis of the Woodsville v. Haverhill lawsuit. They're interconnected and related, Your Honor. The public interest is triggered here. It was a non-consentable conflict because of the appearance of impropriety. So, because at the basis of its conflict, Your Honor, we have two competing municipalities. We have Haverhill and Woodsville, who have been described as akin to the Civil War era North and South, the Hatfields and McCoys. How could one lawyer who worked for the South then go work for the North? How could one lawyer work for the Hatfields then go work for the McCoys? That's what we have here, Your Honor. one attorney who's so invested in one side of a governmental entity should not be able to jump ship to a competing governmental entity when the public interest is triggered. And that is why the New Hampshire rules of professional conduct observe that decisional law in some states limits the ability of a government client, such as Haverhill and Woodsville, to consent to a conflict. And there's other states, Your Honor, that limit and prohibit such a conflict from being consented to, such as New Jersey. And so municipalities operate different than a private entity. And so, Your Honor, I would like the court to observe that DTC's conflict was non-consentable on two separate grounds, under the disinterested lawyer standard and the public interest standard, and the town is entitled to judgment as a matter of law. Now, assuming that this court finds that the conflict was waivable, there was no genuine issue of material fact that DTC did not obtain a proper conflict waiver. Thus, there was not informed consent, and there was not consent in writing. Now, Rule of Professional Conduct 1.7 is the operative rule as set forth in DTC's conflict waiver that is attached as Exhibit 37. In other words, Your Honor, DTC admits Rule 1.7 is the operative rule. Hawkins' affidavit that's submitted in evidence, paragraph 25, he says he discussed the matter with DTC's in-house ethics and risk management counsel to double-check that he agreed with the assessment of potential conflicts, but notably and tellingly, there was no affidavit in the record from Attorney DeRozier confirming Hawkins' thought process. However, it does demonstrate that even DTC's in-house ethics counsel acknowledged there was a conflict by requiring that a conflict letter be pursued. So, Your Honor, Rule 1.7 is triggered because there is a significant risk that representation of one or more clients will be materially limited by a lawyer's abilities to another client, a former client, such as Woodsville, or by the personal interests of the lawyer, as we've seen in the Exhibit 72, and in some of the other emails that are submitted to you, Your Honor. Notwithstanding the existence of a conflict or significant risk, of course, there's an exception to this rule, and it's provided that if the client provides written informed consent in writing. And that just simply didn't happen, Your Honor. The effect of a waiver is only valid if the clients have given truly informed consent. Informed consent is full disclosure. It is not sufficient to leave the client to infer the full nature of the conflict from only bits and pieces or to have some sort of constructive knowledge. The lawyer, not the client, has the burden to demonstrate full disclosure. And DTC has not met that burden. This is, again, Your Honor, where a government client is different from a private client and different from getting consent from a private individual. Full disclosure is not to one individual, Your Honor, it's to the governmental leadership. In this instance, it would be the select board and the town manager. Since Haverhill was a town manager form of government at this time, and the conflict pertained to Woodsville, a subject matter the select board delegated by vote to the town manager to address, DTC would have to give full disclosure to both the select board and the town manager. Now here, Your Honor, DTC admits that it did not provide full disclosure of its conflict to the town manager. In fact, it admits it deliberately remained silent to the town manager on its conflict. On its face, Your Honor, there was no disclosure to the town, as this was a town manager form of government. Now, the record also does not reflect full disclosure to the select board. While DTC has presented affidavits of Steve Robbins and Mike Graham regarding disclosing a conflict arising from Hawkins' prior representation of Woodsville against Haverhill, there was absolutely no disclosure of DTC's conflict arising from Hawkins' personal disdain of town manager Bridget Godwin, who we got burned in the process of the settlement of Woodsville v. Haverhill and then was going to review her performance. The undisputed material facts demonstrate that DTC left it to the town to infer the full nature of DTC's conflict only from bits and pieces of actual or constructive knowledge, Your Honor. That was not full disclosure. The town was also not given a reasonable opportunity to consider the conflict, which is another element to have informed consent confirmed in writing. It would be a reasonable opportunity to understand the risks and alternatives about the conflict and to raise concerns. Now, DTC admits billing the town before even discussing its conflict. There's a billing entry for September 29th, and the conflict was allegedly disclosed on January 12th. DTC bills for 11.75 hours the day it had a purported unrecorded, unnoticed non-meeting with the select board where it apparently disclosed the conflict. And while the DTC's affidavits from Graham and Robbins claim the town was provided with a reasonable opportunity to consider the conflict, those blanket statements, Your Honor, without more can't stave off summary judgment. There was no reasonable opportunity to consider the conflict. They were already billing before they even disclosed it. Haverhill did not consent to the conflict in writing, Your Honor. Again, this is a public entity. A public entity is held to a different standard when approving a written conflict waiver, when the public interest is triggered. One select board member, Your Honor, cannot just sign the conflict waiver without authority to do so, but that's what happened here. In accordance with Haverhill's standard operating procedures, Your Honor, there must be a quorum of the select board to take action. There needs to be a motion, a second, and a majority vote of the board to take place. And there is no genuine issue of material fact that that never happened. There are no governmental records waiving DTC's conflict of interest or authorizing one select board member to sign DTC's conflict waiver. DTC wants this court to find that DTC's conflict waiver could occur in an unnoticed, unrecorded, non-meeting legal consultation. However, not only do Haverhill's standard operating procedures prohibit it, but so does RSA 91A, where meetings need to take place in an open meeting forum. If there was a concern regarding the attorney-client privilege, they could have made a proper motion to enter a non-public session. But there needs to be a meeting called. Here, there was not even a meeting. DTC makes the absurd argument that its reply that waiving attorney conflicts are not subject to a vote. That's what they said in their briefing. And such a rule would be problematic to the attorney-client privilege, citing to page 11 of the Attorney General's memorandum that is referenced in both of our briefing, Your Honor. However, page 11 of the AG's memo does not say what DTC purports it to say. And again, if a public body is concerned about waiving attorney-client privilege, all it has to do is properly enter a non-public session. So the law is clear. A government cannot deliberate and act in a non-meeting. But that is what DTC claims that occurs. It's hanging his hat that there was some sort of deliberation and vote in an unnoticed, unrecorded, non-meeting. So as a matter of law, Your Honor, DTC's conflict was not waived. DTC makes an effort to create a dangerous precedent where a public body can meet with lawyers, deliberate, and act without any notice to the public. That should be rejected, Your Honor. There are no governmental documents demonstrating that the governing body waived DTC's conflict of interest. Therefore, it was never waived. Now, there is a conflict waiver that was signed by one individual, Your Honor. It was the vice chairman of the select board at the time. And this individual was a Woodsville employee. He was a former select board member, Steve Robbins, who had all the DTC invoices sent to his personal home. See, the DTC invoices were not sent to the town offices. They were sent to Robbins' personal home, and of which were only disclosed to the town after he was voted out of office. So he could not have waived DTC's conflict of interest, and there are several reasons why, Your Honor, Robbins was disqualified from voting or taking any action. I mean, one, he was an employee of Woodsville, and as evidence demonstrates in Exhibit 88, Your Honor, he received significant payments from Woodsville. He could not be impartial in waiving a conflict of interest. Moreover, Your Honor, Attorney Hawkins was Robbins' former client. Robbins was Attorney Hawkins' former client, Your Honor, when he represented the Woodsville Ambulance Service against miscoddling in the town. And the text messages between Robbins and Kevin Shelton, Your Honor, who is the Woodsville District Administrator, demonstrate some sort of collusion. Indeed, in one text message on Exhibit 79 and date stamp 341, Robbins admits to having a conflict by abstaining from a Woodsville matter, which he should have done here. Now, the determination as to whether a municipal official has a direct personal and pecuniary interest in the matter, Your Honor, under consideration, or has other interests which would disqualify him from acting, depends on the circumstances of each case. And the circumstances of this case clearly demonstrate a gross conflict by Robbins to sign a conflict waiver for his former counsel at Woodsville, where he worked, to represent Haverhill in a matter that related to Woodsville. Now, deciding to waive a conflict, Your Honor, is not an administrative act of the government. The government, the governing body, the town manager would need to weigh evidence. They would be acting in a judicial capacity rather than an administrative one. And the New Hampshire Constitution mandates that judges be impartial as the lot of humanity will admit. Robbins was not impartial. He was the Woodsville fire chief, received annual compensation from Woodsville for his services, and served at the direction of Woodsville commissioners. He could not be objective to determine whether the town could waive DTC's conflict of interest because of because of Hawkins' prior representation of Woodsville. DTC's conflict waiver is void because of Robbins' conflict, Your Honor. In closing on the conflict of interest, as demonstrated, DTC's conflict was non-consentable under both the disinterested lawyer standard and under the public interest standard. But even if Your Honor finds that the conflict could be waived, it was never waived. DTC is not entitled to attorney's fees, and all other claims in this litigation are moot. The court finds that there was a conflict, it would moot every other claim in this litigation. There would be no whether the select board, quorum of the select board voted to retain DTC, whether the town manager's requirement was a condition precedent, whether any of the equitable claims exist. All those claims would be moot, Your Honor, if this court finds and should find that there was a conflict of interest, and the town would be entitled to judgment as a matter of law. Now, to the extent that those issues are addressed by the court, Your Honor, for instance, the town manager, which is count 2 of the town's complaint, the policy behind a town manager form of government, Your Honor, is to have checks and balances. And DTC avoided them at every step of the way and worked around the law of the land, essentially blackballed the town manager to get hired. Under RSA 37.6 Roman 9, the legislature included a statute that says that the town manager shall have the power, and it shall be her duty, to perform such other duties consistent with her office as may be required by vote of the selectmen. So the select board can have a vote, they can have an additional duty, and that would be the town manager's duty until that vote is rescinded, amended, set aside, or modified. A quorum of the select board voted to give the town manager full authority over all legal matters related to Woodsville. Its precinct, its commissioners, its enterprises. And there was no other vote rescinding, set aside, amending, modifying that decision. Now, as set forth in the town's briefing and in the exhibits, the DRA put a halt to the tax rate because of Woodsville's appeal of Haverhill's warrant articles, which mandated Haverhill taxpayers to fund Woodsville. So the DRA tax rate matter was related to Woodsville. It triggered that action of the select board to have the town manager address that issue. However, instead of following the legal course and conferring with the town manager about the DRA tax rate setting matter, DTC avoided the town manager, even though she was appointed as actually the sole contact for Executive Cindy Warmington to contact the town regarding the tax rate matter. There's simply no logic, Your Honor, to eliminating the town manager and calling it proper procedure. There's also no sense of logic for DTC to claim it didn't need to perform due diligence to understand there was a vote of the select board that provided this additional authority to the town manager, who already oversaw all attorney conflicts and contracts. And there's no contradictory affidavit in the record, Your Honor, that says that. So the fact of the matter is, Your Honor, the town manager's approval was required for DTC to represent the town on the tax rate matter, and that failed to happen. Exhibit 27 shows that the town manager said, hey, DTC, I just find out that Attorney Hawkins is with your firm. He can't represent the town. He represented Woodsville against Haverhill in this matter substantially related, and it would be unethical for him to do it, but they proceeded anyway. On the select board quorum issue, Your Honor, this is interesting because on January 10th, which was well after DTC had been engaged by certain members of the select board, there was a vote of the select board to have the town manager reach out to DTC to determine whether or not they could represent the town on the DRA tax rate matter, and to determine whether there were any conflicts. The meeting minutes say that it was just a referral for the town administration to reach out to DTC. There's emails to that effect. Ms. Codling reached directly out to Attorney Bolt saying, hey, would DTC be interested in representing the town on the DRA rate setting matter, and would you have any conflicts? He said, I would have to perform the conflict check before a definitive yes. And that, Your Honor, led to a line of Attorney Bolt not even responding to the town manager and deliberately remaining silent after even promising to perform a conflict check. So the town manager says, left in the whim after an attorney promises to perform a conflict check. Now, about a week later, Your Honor, the select board attempted to re-vote on the DRA rate setting matter. There was nothing with this purported action regarding the review of the town manager's performance. And the select board had attempted to modify meeting minutes from the January 10th meeting to claim that they actually hired DTC, which is wholly improper and is not proper hiring. They didn't even address the conflict of interest in this action. And so a quorum of the select board, Your Honor, did not vote to hire DTC. And notably, DTC admits that a quorum did not vote to hire it to review the town manager's performance. They said, well, it needed to stay secret. It needed to stay away from the town manager. Well, it's a public employee. Shouldn't a public employee know that they're being reviewed, that the attorneys are being reviewed to review their performance? Yeah, that might produce better results and actually would make government open and transparent as to what RSA 91A requires. So, no, Your Honor, DTC admits that there's no vote for DTC to review the town manager's performance, demonstrate a quorum of the board never voted to hire DTC. There is no contract between DTC and the town because it was never approved by the town manager and it was never conclusively approved by the select board. Now, men must turn square corners when dealing with the government. And to DTC's credit, they bring up a case, they cite the dissenting opinion that says, well, the government should turn square corners with the people. But, Your Honor, that case is inapplicable. It's the case of St. Regis Paper Co. versus the United States. And it's for the proposition, in that case, the Census Bureau said that, the census reports would remain confidential, but the Federal Trade Commission then used the census reports. That's completely an opposite of for a government to retain legal counsel. It's just completely inapplicable. It's the dissenting opinion. DTC should have turned square corners with the government. They didn't turn square corners with the government. There's no contract. Now, turning to DTC's counterclaims, Your Honor, there's no breach of contract because there's no contract. The town owed no duty to DTC. Now, equitable relief DTC turns to equitable relief. Apparently, there's a belief that they may not have a contract, so they filed a lawsuit against the town for equitable claims of unjust enrichment under restitution and quantum error theories. Now, both of those should be denied because of DTC's unclean hands. They've come into equity with unclean hands. Now, if the misconduct is directly related to the controversy at issue, equitable relief is barred. Here, Your Honor, the misconduct is directly related to the conflict of it, the controversy at issue, excuse me. There's numerous tawdry acts engaging in a conflict of interest. Attorney Bolt saying that he would perform conflict of interest checks, promising the town manager that she would. The assistant town manager and town manager both contacting Attorney Bolt by email and by phone, and him not even responding. But then performing background strategy with Attorney Hawkins a few days later as shown in the invoices. That's a tawdry act. DTC claims that it's not a tawdry act, but did not submit an affidavit from Attorney Bolt. And for an attorney to ignore a town manager and a town manager form of government after promising the town manager that it would do something on behalf of the firm is tawdry, and it goes to the heart of the matter. Now, drafting a conflict waiver for Haverhill to imply to not defend the town manager's position on Woodsville, that's tawdry. Misleading the select board on its knowledge of Drummond-Woodson work on the tax rate matter and its potential conflict with the school board, saying, oh, we didn't know about the conflict, but then emails demonstrate that DTC believed there was no conflict. That's tawdry. And now, Your Honor, DTC's tawdry act, with its letter to the DRA, which brings me to the hearing exhibit that's before you today. Its letter to the DRA of January 13th, 2023, where it threatened the DRA, and Attorney Roth responded to that letter, where he said that not only did DTC have no influence in the DRA setting the tax rates, it was the worst conduct that he had witnessed in his 33 years practicing law. So this affidavit just attests that what he wrote was true. It doesn't change the facts, and it should be admitted because DTC makes a big deal that the town didn't have an affidavit from Attorney Roth swearing under oath to his letter. It's just the letter is true to his knowledge and belief. So the town has shown that it has been injured by DTC's conduct, Your Honor, to support its clean hands argument. As provided in the affidavits of Ms. Boucher and Ms. Codling, they attested to the reputational harm that DTC caused the town that's highlighted in Attorney Roth's letter. And DTC provides no contradictory affidavits to that contested fact. So, under RSA 491-8A, the fact is deemed admitted. The town suffered reputational harm at the hands of DTC. DTC has come into equity with unclean hands and is not eligible for equitable relief. Now, Your Honor, DTC claims that the town does nothing to object to DTC's alternative equitable claims, which is demonstrably false. Now, in its objection, Your Honor, the town incorporated by reference its arguments in its principal memorandum on conflicts, which reference both restitution and quantum merit, and it incorporated those by reference. Now, restitution, Your Honor, DTC would only be entitled to restitution for unjust enrichment, which, first, the town was not unjustly enriched by DTC. In fact, it was actually harmed. But for purposes of argument today, Your Honor, a plaintiff is entitled to restitution for unjust enrichment if the defendant received a benefit, and it would be unconscionable for the defendant to retain that benefit. So the party seeking restitution must not only establish unjust enrichment, but that the person sought to be charged had wrongfully secured a benefit or passively received one in which it would be unconscionable to retain. Now, The town did not secure any benefit from DTC, Your Honor. As shown in the town's briefing, another law firm did the work to get the tax rate set. Attorney Roth's letter even says that. Said, DTC, when you sent your letter on January 13th, we didn't even know you represented the town. We were working with town council at Drummond Woodsum to work on the tax rate matter. In fact, we set the rates in spite of your letter, not because of it. Also, Your Honor, in the affidavits of Codling and Boucher, which is confirmed in Exhibit 30 of an email from Drummond Woodsum, Drummond Woodsum was working with the DRA to set the tax rates. And in Exhibit 45, DTC, excuse me, Your Honor, credits Cindy Warmington as doing the work for getting the tax rate set. So we have DTC saying that the executive counselor set the tax rates, forwarding a press release saying that it's accurate. We have the attorney from the taxing authority, Mr. Roth, who testifies under oath the contents of his letter, stating that DTC had nothing to do with the tax rates. And Attorney Roth would be in the best position to determine if DTC did any work on the tax rates, since he was revenue counsel for the DRA, served at the pleasure of the commissioner, and had been working with town council at Drummond Woodsum to set the rates. You know, Attorney Hawkins testifies to the state of Attorney Roth and his motivations in his letter, but then admits in the same affidavit that he never met Attorney Roth. Where does he get that idea? So the town did not retain any benefit from DTC, Your Honor, and on the contrary, the town was damaged by DTC's conduct. It is not unconscionable for the town to not pay DTC and did not perform any work. There's no genuine issue of material fact that DTC can recover under a restitution theory for unjust enrichment. Under the quantum merit, Your Honor, while damages in unjust enrichment are measured by value of what was inequitably retained, in quantum merit, damages are based on the value of the services provided. So there's three elements to this claim, Your Honor. Services were rendered to the defendant by the plaintiff with knowledge and consent of the defendant, and under circumstances that make it reasonable for the plaintiff to expect payment. As previously argued in our briefing, Your Honor, the town did not consent to DTC performing services under the circumstances. It was not reasonable for DTC to expect payment from the town as it sent its invoices to the personal home of a select board member, which were not given to the town until after that individual was voted out of office. DTC did not perform the services that they were duplicative of another law firm. As shown in the emails, as testified to Attorney Roth in his letter. And with regards to the town manager's performance, Your Honor, there's no evidence that any work was done that was of any value. And Ms. Boucher testified that another law firm, the Mitchell Municipal Group, was actually working on that matter. So no, Your Honor, it was not reasonable for DTC to expect to be paid on when it engaged in a conflict of interest. It was not reasonable for DTC to expect payment for legal services when one selectman signed its engagement letter on February 8th and it began billing on September 29th. It's not reasonable for DTC to expect payment, Your Honor. Under these circumstances, DTC should have never expected payment. There is no genuine issue of material fact, and DTC is not eligible for equitable relief under quantum merit theory. One thing I'd like to point out, Your Honor, is that the attorney-client relationship in New Hampshire is unique. It's formed by implication. The evidence demonstrates that there was implication of an attorney-client relationship. However, that would only support the town's argument on the conflict of interest issue, because a lawyer would not have any duty to disclose conflict, to follow the conflict laws, if there wasn't an attorney-client relationship established. To put that in our briefing, Your Honor, I would ask the court to consider that. Your Honor, DTC has made an argument that the town should pay its legal fees for litigating this case. Your Honor, this case was filed in good faith. The New Hampshire follows the American rule pursuant to which each party is generally responsible for its attorney's fees, and while there are exceptions, Your Honor, none of them apply in this instance. The town's complaint was filed was served, Your Honor, on the day, September 25th of 2023. That's the day that Attorney Hawkins said, "Town, you need to pay up or I'm taking you to arbitration." The town served its complaint on September 25th of 2023 to avoid having to go to arbitration, to fight a one-sided battle. This was filed in good faith, Your Honor, given all the evidence and I would hope the argument today. And, you know, the former select board chairman, Phil Blanchard, had also filed an affidavit, Your Honor, saying that he completed reasonable due diligence and to determine whether there were any action waiving DTC's conflict of interest before authorizing the filing of this case, and he said no, there wasn't. The invoices sent to the personal home of a select board member rather than town offices, but then being forced to pay them. And even DTC's supporting witness, Your Honor, Selectman Knapp, voted to file this lawsuit to determine who's right. The lawsuit was filed in good faith, and the town should not have to be subject to any attorney's fees, Your Honor. On the other hand, DTC has engaged in bad faith conduct and should be responsible for the town's attorney's fees, as it knew it had nothing to do with setting the tax rates, as evidenced by Attorney Rowe's letter, where DTC withheld Exhibit 72, Your Honor, where Attorney Hawkins writes to former Woodsville Commissioner Kevin Shelton that he hopes that Bridget Coughlin got burned in the process of the settlement of the Woodsville and Haverhill litigation, and that he hopes that Woodsville received a lot of money from Haverhill. And the costs have been compounded in this litigation, Your Honor, unnecessarily. The integrity of government is on the line in this case, Your Honor. What sets this case apart is we are dealing with public entities, the public's conflict waiver, and the integrity of the people's government. This is not the select board's government. This is not the town manager's government. This is not DTC's government. This is the people's government, and they should have a choice as to whether a conflict should be waived. And in this instance, it's just non-consentable under both the public interest standard and the district's lawyer standard, because the public interest is triggered.
Attorney Klein,
Thank you.
well, all right. So, counsel, we don't. All right. Well, fortuitously, I had bail hearings that were scheduled at noon for people who are being held on warrants, but apparently I don't have to do that. Why is that? Sorry? Oh, we did it. All right. So, I was going to offer you to come back, as this matter was scheduled for half an hour, and Plaintiff's counsel's taken an hour.
Oh, Your Honor, this was scheduled for an hour and a half.
Well, that's not according to what I have here, but in any event.
And so I tried to take half the time and give Ms. Lynch.
You're on. So I don't have bail hearings. So if you're ready, now's your chance.
I am, Your Honor. Thank you.
Go ahead.
This case has perplexed me from the inception because it's a really simple breach of contract issue that has been made unnecessarily and exceedingly complicated by the town. Let me talk about the facts before I get into argument. Your Honor's right, the record is huge. Unnecessarily so, and I empathize with the court that you're going to need to pierce those pleadings to get down to the actual material facts, which are undisputed, and let me try to help Your Honor in that effort. DTC's additional statement of material facts, 119 through 147, contains everything you need to decide this case. I'm going to point you to the specific exhibits that are most critical. Exhibit 14 Email from Select Board member Kevin Knapp to DTC attorney. Hello, Chris. Last night I received full board approval to talk to you guys about setting up a non-meeting. In the motion, it was approved for you to charge the town of Haverhill at your hourly rate. That's when the Select Board unanimously retained DTC on the personnel issue. Exhibit 14. Exhibit 16, January 10th, emergency public meeting minutes, during which, when read in conjunction with the affidavits, including by public members who witnessed it, the Select Board unanimously cancels the use of Drummond Woodson, and retains DTC on the DRA tax rate setting issue. Exhibit 43, January 17th, public meeting minutes, during which the Select Board unanimously ratifies the retention of DTC and clarifies that the 110 vote was to retain DTC. You can also listen to the Select Board discuss this ratification at Exhibit 69. I submitted a clip of the Zoom public hearing, minutes 9:12 to 14:19. You can hear town administration, the town manager in that meeting, tell the Select Board that the appropriate tact would be to ratify that vote to clarify the public record, and then the Select Board goes ahead and does that. Exhibit 8, DTC's bills, showing just under $14,000 in legal fees incurred, including multiple entries showing that the town manager was consuming DTC's legal services over multiple dates. Amended complaint, Exhibit 17, signed engagement letter. Exhibit 37, signed waiver of potential conflict. That's the record, Your Honor. It's not a 100 exhibit case. It's a half dozen exhibits and a half dozen affidavits, 30 facts, simple breach of contract matter.
Somebody have a cell phone that's on? Because it interferes with the record, the electronic record. Anybody in this room have a cell phone that's operating? Not on airplane mode?
I put it on airplane mode, Your Honor.
I have mine on Do Not Disturb. Is that enough?
Probably not.
Airplane mode?
They're off.
Your Honor, is there anything I need to repeat for the record?
I don't know. No?
Okay.
No, it's
Thank
just
you.
making background noise. Go ahead.
Thank you. So those are the key facts, key exhibits. There's a lot of irrelevant, immaterial conjecture introduced by the town. We have a half dozen affidavits or more submitted by the town from multiple people, none of whom were engaged in the conversations with DTC. They have no relevant knowledge. We have newspaper articles that are hearsay. We have case law from half a dozen states and circuits that aren't New Hampshire, that's completely irrelevant. We have text messages that have nothing to do with the case. We have tapes of Select Board meetings from 2023 after the operative events occurred. The list goes on, I brief it. There's just a lot of material. You're gonna have to kind of peel this back and trim the fat. But when you do, you're gonna see the relevant material facts are in dispute. Now, the declaratory judgment action, the town seeks summary judgment on 3 counts. Count 1, boiled down. Did the Select Board retain DTC? Yes. Unqualified, yes. Count 2, was it actually the town manager as opposed to the Select Board that had the authority to retain DTC? The answer is an unqualified no. And count 3, whether there was a conflict, and if so, whether it was properly waived. There was no conflict, but if there was absolutely appropriate waiver. You have the waiver in the record. So let's go through this in turn. Count 1. Did the Select Board retain DTC? Yes. I've already directed Your Honor to Exhibit 14, The board retains DTC on the personnel issue via email dated 1/4/23. On 1/10, it expands the scope of the retention to include the DRA issue. And it's notable when you look at that exhibit, Your Honor, exhibit 16 and 17, that they canceled the use of Drummond Woodsum because Drummond Woodsum informs the town it has a conflict and it's not going to go waiver fast enough, and the town is facing a dire financial crisis. The tax rates need to be set. There's talk of taking a $2 million tax anticipation note, and even if that's done, town's out of money in March. It had to be addressed, and they couldn't wait for Drummond Woodsum to clear a conflict. DTC cleared a conflict, DTC was retained. January 12th, all 5 sitting select board members meet with DTC in a non-meeting, are briefed at length on the potential for conflict. It's determined after a nuanced evaluation of the actual scope of retention, what is the select board, as authorized representatives of the town, asking DTC to do. There's no actual conflict. I'll discuss the conflict a bit more later. The board says we waive the conflict. Woodsville says we waive the potential conflict. There's a signed waiver confirming the waiver of conflict. There's a signed retention letter confirming the retention in the hourly rate. It cannot be clearer that an attorney-client relationship exists, and in fact, I think the town has waived the argument that there was no attorney-client relationship, both at argument today and at pages 2 and 9 of its reply briefing from August 30th. So I'm not sure counts 1 and 2 are even an issue anymore. If an attorney-client relationship exists, judgment enters in favor of DTC on counts 1 and 2 of the town's deck action. Count 2 of the deck action was it actually the town manager who had authority to retain counsel? No. The statutory scheme is abundantly clear. The select board manages the prudential affairs of the town in all respects. And any time the select board is authorizing the town manager to act, it is doing so always at the direction and oversight of the select board. The select board is the ultimate authority. It can revoke a delegation of authority at any time. There is nothing in any statute or any case that suggests that some delegation of authority by the select board is unrevocable. That could lead to an absurd result. The town manager also didn't have authority to retain counsel in this case because the town manager wasn't primed. The town was. The select board manages the prudential affairs of the town. Logically, it just also doesn't make sense that the town manager in this instance would retain the attorneys. With regard to the personnel issue, it would be absurd if an employee could choose the employer's counsel retained to investigate and review them. That doesn't happen, ever. The town manager was also excluded from the retention of counsel on the DRA tax rate issue because the select board believed and advised its attorneys that it believed the town manager created the issue. You have to flash back a little bit to May 2022. The select board, and this is in evidence, says to town manager Codling, what's going on with the DRA? What are the communications on warrant articles 27 and 28, which were voted in by a majority of the voters? This is the will of the town, the will of the voters. And she says the DRA doesn't really communicate in writing. Well, come to find out, select board member Williams sends a 91A request to the DRA, and it's responded to, interestingly enough, by Attorney Klein, who used to work at the DRA, and produces email upon email upon email upon email between Codling and the DRA in which she is encouraging the DRA to disallow the warrant articles. It was those communications that ultimately led to the disallowance of the warrant articles, the dispute between the DRA and Woodsville, and the DRA's refusal to set the tax rate for the entire town. The select board, acting on behalf of its constituents, was not going to include Ms. Codling in an effort that they felt like she created the problem. So, retention by the right group. Ms. Codling did not have authority to retain counsel. There is some reference to this March 2020 vote of the then select board giving Ms. Codling authority with regard to legal matters related to the Woodsville precinct. That vote occurred contemporaneously, days or weeks before this Woodsville litigation in 2020 was filed. That litigation was limited to the interpretation of a statutory funding scheme and the funding of departments in 2019 and 2020. When the board is giving Ms. Codling authority to address that litigation, it would be absurd to think that they're giving her authority to address every issue that touches upon Woodsville in perpetuity, including the issues in this case, which didn't exist at that time. We're projecting 3 years into the future. We don't know what's going to happen. And the facts, as they evolved, showed that it was actually not appropriate to include Ms. Codling in the retention of counsel on this particular issue. Even if that March 2020 vote operated to give Ms. Codling some authority over the Woodsville precinct in perpetuity as to any matter known or unknown, foreseeable or unforeseeable, which it didn't, because the select board is the ultimate authority, they can revoke that at any time. Expressly, impliedly, through action, through inaction, they are the authority. They retrieve the counsel. So we have a contract. We have an admitted breach. That's not a dispute. Town says we haven't paid your legal fees. So based on that, I believe that summary judgment can enter in favor of my client on count 1, count 2 of the DAC action, and on the DTC's counterclaim for breach of contract. Now, the town says, well, there was a contract, and yeah, we breached it, but it was voidable because there was a conflict. There was no conflict. So, Rule 1.7. An analysis of if there's a conflict based upon Attorney Hawkins's former removed representation of Woodsville in an unrelated matter. So the first inquiry, are the matters the same or substantially related? No. They're not the same because the Woodsville litigation is settled. There's docket markings from May 2022 dismissing the case, and well before the docket markings and well before the settlement, Attorney Hawkins had left that firm. He was at Define Willamette and joined DTC, had withdrawn from the case. He wasn't involved in the settlement. The case was done. Not the same case. Not substantially related because that case, and Your Honor can take judicial notice of the decision on partial summary judgment in that case from, I believe it was Judge Orenstein, was about an interpretation of the statutory formula for funding certain departments in Woodsville. It wasn't about personnel issues that arose in May 2022, years into the future. It wasn't about warrant articles 27 and 28, which haven't been proposed or voted on or passed. That was 2 years into the future. Okay, they're not related. The dispute with the DRA arose because the DRA, for reasons we can speculate about, but are probably immaterial on this record, chose to not set the tax rates for the entire town. The entire town. This was a political maneuver, an apparent political maneuver. The second inquiry, if you even get to that part under 1.7a, is, well, if they're the same or substantially related, is the attorney for the former client in possession of information that would be materially adverse if used in the current representation? And the answer there is no. I mean, that's not even briefed by the town. Attorney Hawkins, who sat on the New Hampshire Bar Association Ethics Committee, who's held municipal office, was extremely sensitive to the conflict issue, and it's probably his sensitivity to the issue that is causing some of the confusion. Because he didn't even, I think, need to go to the steps he went to. This was an abundance of caution type of advisement and waiver. He determined properly that there was no conflict because the positions he was being asked to advance, as refined by the select board during that 112 meeting, had nothing to do with the Woodsville litigation. The select board said, we don't want you to advance a Woodsville position or an anti-Woodsville position. We want you to advance a whole town position. Go, please, get the tax rate set. Forget warrant articles 27 and 28. We don't want to reopen the litigation. We don't care about those warrant articles. Peel them off and set all of the tax rates except for those ones. So based upon the client's description of the scope of representation, there was no conflict, and certainly no conflict on the personnel issue, where Cobbling wasn't the client, and they were being asked to assist with her review. It's worth noting here, and I don't think it's material, I think it's a distraction, this idea that Attorney Hawkins has some personal animosity toward Ms. Cobbling is conjecture, speculation. The record actually shows that when DTC assisted the select board with her review, it gave her a very fair review and was extremely careful to tell them to review her with care and consideration. So just not supported by the record. For those reasons, on deck count 3, judgment can also enter in favor of my client. There's no conflict. And if there was a conflict, it was briefed and waived by all parties, Exhibit 37. And if you read Exhibit 37, Your Honor, it's actually a really good conflict letter. It's sort of, to me, a model conflict letter. It quotes 1.7A1 and 2. It explains the standard. It gets into the 4 factors that need to be analyzed under 1.7B, and explains why Mr. Hawkins thinks those are met in this case. So it's really a model conflict letter. It's a strange to claim now that there's no waiver. On my client's counterclaims, if for some reason this court were to find that no contract exists, which I don't think the court can find that based on the town's own admissions, my client would still be entitled to equitable relief. It is well established in this state that a municipality can be stopped. There are some caveats to the rule or specifics. Of course, the government actor has to be acting within the prescribed scope of their authority. Now here, and this is an affidavit from my client and from select board members, and in the statutes, a select board member reaching out to council and saying, we'd like to retain you on behalf of the town is commonplace. There's nothing ultra vires about that. That's exactly how an attorney would expect to be retained by a municipality on these types of issues. Now, if DTC had been reached out just by somebody in sanitation or animal control, does this person have authority to retain me on a DRA tax rate setting issue? And let me look into this. But a sitting select board member representing that there's been a unanimous vote to retain them, they're stopped from claiming that there wasn't a relationship. Even if there was some type of ultra vires conduct, which there wasn't, it's a selectman, the case law is abundantly clear that the subsequent ratification of that type of ultra vires conduct is equivalent of original authority. And that's what we have here. I directed the City of Concord case, the Amazon case, the appeal of Sanborn, all in my brief. We have a ratification in the public record on 117. Again, that's Exhibit 43, Your Honor. And even if that's not enough, which it is, we have implied ratification by both the Select Board and the Town Administration's continued consumption of DTC's legal services. Exhibit 8, if you look at the entries. Let me speak here a bit about this idea that there wasn't a proper timely signed engagement letter. There's no rule in New Hampshire that you need a written engagement letter unless you're working for a contingency fee. That's Rule 115. Not a contingency fee in this case. You can see in Exhibit 14 when Mr. Knapp and Mr. Hawkins are communicating, he's quoting the rate, extremely reasonable, $200 per hour, and the board's agreeing to it. The commentary to 1.5 makes clear you don't need a written agreement in that case. Read in conjunction with the McCabe case, an attorney-client relationship is formed not when some formal writing exists, but when a person reaches out to an attorney seeking legal services, and the attorney responds by providing them. It's the intent of the parties. It's a simple contract analysis. The affidavits and the deposition testimony here make very clear, beyond dispute, that all the relevant people, select board members, the DTC attorneys, were operating under the belief that they had an attorney-client relationship and that their communications were privileged, and they acted in accordance with that privilege. Rule 1.5 also says that if you do choose to do a writing, it doesn't need to be signed before work begins. It just needs to be signed within a reasonable time thereafter, which was done here. We have the non-meeting with the select board on 112, and the retention letter is signed 131. Exhibit 17 to the amended complaint. Within a couple of weeks. Perfectly reasonable, particularly where you're operating under a really exigent circumstance. Attorneys aren't held to that level of formality. They're told to advocate for their client and do what needs to be done on a time-sensitive basis. Let me now respond to just a few points raised by my brother either today in oral argument or in the briefing. There's some suggestion that my client has admitted there's no contract because we didn't move to compel the arbitration provision in the engagement letter. That's just not true. I refer to my September 10th briefing. The arbitration provision in the engagement letter is specific to fee disputes, and it says that the parties will use the New Hampshire Bar Association fee resolution program as needed. As I'm sure your Honor's aware, that's a forum where the parties agree there's a contract, but they're disagreeing maybe on the amount of time spent on a particular task. Hey, you billed me 50 hours for this, and I wasn't expecting that. That seems just like too much. I was expecting 20, 25 hours. You sit down, you arbitrate, you have a discussion about the work that was done and whether it was appropriate, and you attempt to resolve the dispute by mediation, then arbitration. If you look at the dispute resolution website, it is very clear that that body does not have jurisdiction to decide issues where there's a dispute over whether a contract exists in the first case or where ethical issues were raised. So we didn't need to move to compel arbitration because we couldn't. It was outside the jurisdiction of the arbitration provision. Now, if your Honor agrees that there's a contract and it was breached, you can refer this to arbitration for an actual entry of judgment on the fees. I don't think that's necessary. We're here now. Let's resolve the issue and have judgment enter fully. But if you look at my briefing again from September 10th, the New Hampshire Bar Association is clear that if there's a judicial referral and there's no dispute about a contract or an ethical issue, that it can decide the fee issue. With that, Your Honor, I would rest. Oh, I'm sorry. Let me address one more issue. This argument that my client is not entitled to equitable relief, if we even get there, because we came into equity with unclean hands. That's an affirmative defense that needs to be proven by the town, and all we have here is speculations and allegations, nothing proven. Some of the tawdry acts that the town addresses in the brief and argument. Attorney Bolt didn't respond to the town manager's request for conflict clearance. Well, yeah, at the direction of their client, right? At that point, they're retained by the town and told by the select board to please exclude her from these conversations for the time being, because she's part of the genesis of the issues for which counsel has been retained. That's not tawdry, that's following client direction, legal client direction. Tawdry Act number 2, the conflict letter says we're not going to advance certain positions. Well, yeah, it was the detailed, nuanced, factual analysis of the scope of representations. What positions need to be advanced and which don't, that determines whether a conflict. Of course they had to outline what positions would and would not be advanced, because that was the basis of the conflict waiver. That's not tawdry, that's good 1.7 conflict practice. Tawdry Act number 3, something about the Peter Roth letter and DTC didn't actually do anything. I'm not aware of any law or rule that would bar equitable relief because the town's opponent, their adversary, doesn't like what the lawyers did. That doesn't make sense. It's irrelevant. Very quickly, the town just asked for an entry or an award of its attorney's fees and costs, not raised in the briefs. We did raise that in the briefs. I think it would be perfectly appropriate for Your Honor to enter an award of DTC's fees and costs against the town in defending this frivolous action. As the record demonstrates, the sitting select board members, we have affidavits from Steve Roberts, Mike Grant, deposition testimony from Kevin Knapp. We retained DTC, they did what we told them to do, we liked their performance, pay them. Why are we here? There has been many more dollars spent litigating this case than was principally at issue to begin with. Attorneys can't be held to this standard where they need to jump through a series of unknown, hidden hoops to be retained. DTC was contacted by a select board member and retained. Period. They need to be paid for their work. With that, I would rest unless Your Honor has any questions.
I don't. Attorney Klein?
Yes, Your Honor, thank you. A few things just to address that Ms. Lynch raised. The exhibits for the January 4th email from Selectman Knapp, Exhibit 14, that's disputed. There's no action of the government, one, authorizing DTC to be retained or canceling the use of Drummond. January 10th, which was Exhibit 16, that's disputed. That the actual meeting minutes demonstrate what I represented to the court, that the select board took action to have town administration reach out to DTC to determine whether they were available and whether they had a conflict. It wasn't to hire them. And on January 17th, there was no action to waive the conflict of interest. It was to amend meeting minutes. Now, DTC wants this court to find that there was some sort of action, deliberation and action can occur in a non-meeting, in an unnoticed, unrecorded non-meeting in contravention of RSA 91A and Haverhill Standard Operating Procedures. That should just not be allowed, Your Honor. Now, with regards to the attorney-client relationship that was raised, Your Honor, New Hampshire law does say it can be done by implication. It doesn't say there's a contract. There could be an attorney-client relationship. It doesn't mean it's legitimate. Counts 1 and 2 are whether there's a contract, and there's clearly not a contract. DTC's wrongful pressure and forceful actions created this relationship by implication. Now, as for this response to the 91A that Ms. Lynch brought up that was done in early 2022, I processed 91A requests for the DRA. I was not substantially related in anything. I left a couple months after. As for Rule 1.7, Your Honor, the issues regarding to the DRA tax rate matter and the Woodsville v. Haverhill litigation are substantially related. They both pertain to highway funding. They both pertain to Woodsville's efforts to have Haverhill taxpayers fund Woodsville. That's the core of each issue. They're substantially related. This was not an issue of Attorney Hawkins being on the ethics committee and holding numerous town positions. If that was the case, then DTC should have declined representation. Apparently, there's an unsworn statement from Hawkins in his affidavit saying that DTC's in-house risk management and ethics lawyer looked at this and apparently felt there needed to be a conflict waiver. So that was wrong. Now, regarding estoppel, Your Honor, it was raised. It's raised in our briefing. I won't bring it up again, except to point out that there was unreasonable reliance. The DTC had met with Mike Graham, former select board member, in May of 22, wasn't hired. Met with select board member Kevin Knapp in September and October and November and wasn't hired. I mean, there was unreasonable reliance on those individuals to say, oh yeah, you're hired, but in all the other communications, they weren't hired. There were simply no exigent circumstances, Your Honor, for DTC to be hired in this instance. As the record reflects, Drummond Woodsum was working with town council at DRA and with town administration and ultimately resolved the tax rate matter. And, regarding the arbitration provision, Your Honor, at any point in this matter, DTC could have filed a motion to stay to compel arbitration. We would have gone through the 4-factor test, likeliness to succeed on the merits, whether the public interest is triggered, whether the balance of equity swings. I mean, that could have happened, but they chose not to. And regarding Attorney Roth's letter, Your Honor, that was discussed as a Todd react because Attorney Roth discusses DTC's absurd conduct and said it's the worst that he's seen in 33 years, and it goes hand in hand with the affidavits of both Codling and Boucher that testify that the town suffered reputational harm. And so Attorney Roth had said that, look, I haven't seen conduct by an attorney like this in 33 years. And it just demonstrates the reputational harm that the town suffered, where there's no contradictory affidavits submitted to the contrary. And yes, the town raised attorney's fees, Your Honor, and it was requested in the town's principal motion. It wasn't briefed because that would be for subsequent briefing. So yes, the town did request attorney's fees. As demonstrated, Your Honor, DTC engaged in a conflict of interest. There's no documents that demonstrate that the conflict was waived by a quorum of the governing body. It supposedly happened in a unnoticed, unrecorded, non-meeting in contravention of RSA 91A. That's not good government, that's not the law, and then this court shouldn't create new precedent to allow lawyers to meet with government leaders and to have backdoor dealings without being open and transparent as RSA 91A requires. So, Your Honor, under the disinterested lawyer standard and under the public interest standard, DTC engaged in a conflict, and the town should be entitled to judgment as a matter of law. Thank you.
Do you wish to respond?
Two extremely quick points. And I know Your Honor wants not just doing. We keep hearing about Drummond Woodsum. Drummond Woodsum was operating under an unwaived conflict, and that's not an issue, but DTC's retention with a conflict waiver is perplexing. I don't follow it. And it's just sort of indicative of the issue in this case, which is the town's position is we didn't follow our own rules, so you don't get paid. A justice abounds in that position. Government and square corners with the people. A contract existed and was breached, and I'd ask that judgment enter in favor of my client for $14,000 plus accrued interest plus statutory $1,000 for frivolous litigation plus attorney's fees.
When you said didn't follow its own rules, you mean, are you agreeing that there was no public session approving the contract with your client?
No, there was. On January 17th, there was that ratification. I'm just saying they keep sort of identifying that 117 ratification was insufficient. Well, town administration and everyone else was in the room, and they said, do this. This will be sufficient. You can't say one thing, have the select board act on that advice, and then a year later say, well, that wasn't right, so we're not going to pay. That doesn't make sense. This isn't just about attorneys. Any vendor. How would any vendor ever be sure that they'd be paid when contracting with the town if the town could go into the time machine, pick apart the minutia, and say, we told you to do this and you did this, but that's actually wrong. We're not going to do it. The Amerzine case, the ratification to the express or applied, there was a contract, but if not, there's certainly an estoppel as to the town.
Attorney Klein, you want to say something? Go ahead.
Yeah, thank you. Drummond Woodson was not operating on an unwaived conflict. It was dealing with the tax rate matter. There's emails and memos in the record. They discovered that there could be a conflict because the tax rate implicated other entities and received a waiver from the town manager and continued to work.
There's no fully executed waiver as to Drummond Woodson in the record. It doesn't exist.
If Your Honor would like me to provide the fully executed waiver, I would be happy to.
And I would object the record's closed. It hasn't been produced in discovery.
It was produced, Your Honor. And regarding this, the January 17th purported ratification, that never even addressed the conflict of interest. That never addressed waiving the conflict of interest. The conflict of interest was never waived in a public meeting, in a non-public session. It just happened in a private, it purportedly happened in a private meeting where two of the select board members have attested it did. However, Selectman Knapp, who was deposed, said he doesn't recall any meeting where DTC's conflict was waived.
Anything else?
I refer to the briefing in the record, Your Honor. Thanks for your time.
All right, thank you. I'll take the matter under advisement. Have a good afternoon.